Okay, so we're in the Tosefta for Makkot. So the Tosefta is basically a supplement to the Mishnah. So a lot of times when we hear the statement is taught in the Braita, it's referring to material that we find in the Tosefta. So this is Makkot, Parak Aleph. So 1, it says, a perjured witness is not sold on account of paying compensation for perjury. Rabbi Akiva says, also, he does not pay restitution by reason of his own testimony, for it is a fine. And for any matter which is deemed a fine, one does not pay restitution on the basis of his own testimony. Witnesses who said, we testify concerning Mr. So-and-so that he borrowed Mr. such-and-such 200 zoos on such and such a day in such and such a place. And others came along and said to him, how in the world can you give evidence in this matter? For lo, the lender or the borrower was with us on that day in such and such a place. These are not deemed perjured witnesses, but their testimony in any event is null. But if they had said to them, how in the world can you give evidence in this manner? For lo, you yourself were with us in such and such a place. Lo, these are deemed perjured witnesses. And they pay restitution on the basis of the testimony of the others, if they were inscribed on the writ, so, quote, on the 1st of Nisan in the year of release. And others came along and said to them, quote, how in the world can you have signed that writ? For lo, you were with us on that day in such and such a place. Their testimony remains valid, and the writ remains valid. For I said, perhaps one post-dated the writ and wrote it out. A writ which is dated on the Sabbath or on the 10th of Tishrei, or the Day of Atonement, Rabbi Yehuda declares valid, and Rabbi Yoshi declares invalid, because you don't write on Shabbat or Yom Tov. So it's, if somebody has something that says something about that, you can assume that they didn't write it on that day, that they would have had it pre-written. So let's see. A writ which is dated, okay, so Rabbi Yehuda declares valid and Rabbi Yoshi declares invalid. Said to him Rabbi Yehuda, such a case came before you in Sephoros, and you declared the deed to be valid. Said to Rabbi Yoshi, I never declared such a writ to be valid, but if I did declare it valid, I declared it valid. So I declared it valid. And the witnesses who testified, we give evidence that Mr. So-and-so blinded the eye of his slave, and afterward he knocked out his tooth. So the master says, and who turned out to be perjurers? They paid compensation to the slave. If they said, quote, he knocked out his tooth and afterward he blinded his eye, so the slave says, and they turned out to be perjurers, and they paid to the master. If they said, quote, he blinded both of them at once, or, quote, he knocked out both of them at once, and others came and said, quote, not so, but it was 2 of them in succession, and they turned out to be perjurers, they paid to the slave. And if they said he blinded both of them one after the other, or knocked out both of them one after the other, and others came along and said, not so, but he did both of them at once, and they turned out to be perjurers, they paid to the master. He blinded the eye of his slave, and lo, he is yet subject to him and working for him. And they brought out to be perjurers, and they turn out to be perjurers. They paid both the value of the slave and the blinding of the master, in the blinding to the master. Witnesses who say, we testify concerning Mr. So-and-so that he has divorced his wife and not paid off her marriage settlement. And so does the woman claim, and they turn out to be perjurers. They pay off the value of her marriage contract to the husband. If they say that he has divorced his wife and has paid off her marriage contract, and so does the husband claim, and they turn out to be perjurers, they pay off the value of her marriage contract to her husband. If they say that he has divorced his wife and not paid off her marriage contract, for lo, she is yet in his domain and serving him, and they turn out to be perjurers, they do not rule that they should pay off to her the value of the marriage settlement, but they pay only the value of deriving benefit from her marriage settlement. And is there a value deriving benefit from her marriage settlement? Yes, they make an estimate of how much a man will be willing to pay now for the marriage contract of this woman, on the condition that she should die in her husband's lifetime. Her husband will inherit her estate, including the said marriage contract. But if it is after the death of her husband, she will inherit her marriage settlement, and they will inherit her. In accordance with that estimate, they pay restitution. The witnesses who said, we testify concerning Mr. So-and-so that he has stolen the forbidden fat of his fellow, but has not eaten it. He has stolen the carrion of his fellow, but has not eaten it. And they turn out to be perjurers. They are flogged, and they pay compensation for the value of that which they accused the man of stealing. For it was with that stipulation that they gave evidence against him. With the stipulation that he be flogged and pay compensation, if they said he has stolen the forbidden fat of his fellow and eaten it, stolen the carrion of his fellow and eaten it, lo, this one is flogged, and is also liable to pay compensation. For it is in commercial matters that Scripture says, you shall not bear false witness against your neighbor, Exodus 20:16. And in matters pertaining to flogging, it says, and you will do to him as he conspired to do to his brother, Deuteronomy 19:19. The words of Rabbi Meir, if he is put to death, the words of Rabbi Meir, and the sages say, and I have to back up a little bit. It says, in matters pertaining to flogging, it says, and this would be a quote from Rabbi Meir, and you will do to him as he conspired to do to his brother, Deuteronomy 19:19. Okay. Now it says, and the sages say, meaning the majority, in proportion to his offense, Deuteronomy 25:2, if he is put to death, he does not have, in addition to pay compensation. If he is flogged, he does not have, in addition to pay compensation. But sages concede to Rabbi Meir that if they gave testimony concerning him, that he is the son of a divorcee or of a woman who had performed the rite of removing the shoe, or that he was a nettin or a mamzer, they are flogged with 40 stripes. At what point are perjured witnesses liable to pay compensation? At the point in which their testimony is spelled out in court. Once it comes out, their evidence has caused them to be declared liable by the court. At that point, the perjurer has to pay compensation, just as in the case of two witnesses. If one of them turns out to be a relative or otherwise invalid, the testimony of both of them is null. So in the case of three, if one of them turns out to be a relative or otherwise invalid, the testimony of all three of them is null. How do we know that the same rule applies even in the case of 100? Scripture says witnesses. So if the witnesses state, we give testimony against Mr. So-and-so that he has killed someone, and others came and proved them to be perjurers, the defendant is declared valid. The first group of witnesses is liable. And then others came and proved them to be perjurers. The defendant is now liable. And the first group is exempt. Well, the second group is liable. If one group comes in and another group goes out, even if they are 100, all of them are exempt. Rabbi Yehuda says this is a conspiracy, and the only ones to be put to death are those of the first group alone. Rabbi Yoshi said, under what circumstances, in the case of trials for capital crimes, but in the case of trials for property litigations, the testimony can be confirmed with the remaining valid witnesses. Rabbi Meir says, even in the case of litigations of property, if he did not know that they had a relative or one who was invalid, let the testimony be confirmed by the remaining valid witnesses. Rabbi Dostai ben Yehuda says, perjured witnesses against whom others came and proved their perjury, those who prove the latter to be perjured and are perjurers themselves are exempt from all punishment. One who has been proved a perjurer is invalid for giving testimony in regard to any manner of the Torah. The words of Rabbi Yehuda. Said to him Rabbi Yoshi, under what circumstances, in the case of one who has been proved a perjurer in a capital case, but if he has been proved a perjurer only in a property case, he is invalid only in regard to that specific manner of testimony alone. And that is the end of Parak Aleph of the Tosefta Makkot. Thank you.